My name is Attorney Susan Lawson. I'm another partner here at the Rossen Law Firm, and I am board certified in criminal trial law, meaning I'm an expert. This is what I've done my entire career. And firearms are a big part of criminal law and criminal defense. And I know Adam spoke to you about a lot of the legislative changes regarding concealed carry, and Krista went over enhancements, minimum mandatories, penalties, sentencing. What I'm here to talk to you about, I think it's really important to discuss the Florida gun laws, which I know Adam covered some, but it's never too much to hear because it's obviously important to know what the laws are. Both we practice federally and on the state level. I'm licensed in Florida, Maryland, and DC, and it's important that you know the gun laws for your particular state. I'll be speaking about some of the laws here in Florida, but every state has different laws, and it's very important to keep up to date with the laws because, as I'm sure you all know, it's they're always changing. So we're here with the most up-to-date laws, and specifically the laws in Florida. And criminal defense, as far as firearm gun laws, are very important to be able to properly advise your client, the court. And I'm actually going to be going through some cases I've had, some real life examples. So hopefully this isn't too, the statutes are important and the law is important, but I also want to try to keep this interesting since I know I'm the last presenter and it's probably getting later in the day for everybody. So before we get into, I just wanted to give you an overview of, I'll be talking about briefly, specifically some gun laws in federal and Florida. And then afterwards, I'm going to spend a lot of time speaking about risk protection orders or the red flag laws, and because that's a newer area that we're seeing a lot. And we've handled a ton of risk protection order cases, and it's very, it's newer. So not everybody knows the best way to handle those cases and the information needed to be able to handle those cases. So those are the topics I'm going to be presenting. So let's get started. Again, this is Florida gun law. My name is Attorney Susan Lawson. And so briefly, again, we do federal cases, and there are a lot of cases that are charged federally. So it's important to know, just for this presentation, I'm not going to get into too much detail regarding the federal law, but it's important to know there's 10 categories of individuals who are not eligible to purchase or possess a firearm under federal law. Okay, and this is governed by Title 18, United States Code 922 G1, and then the subsection. The materials can be provided, so I'm not going to read too much, but let's go through these 5 areas or categories of people that are prohibited under federal law from possessing or purchasing a firearm. So the first one is if you've been convicted of a felony. So again, this is on the federal level. A conviction, we all assuming know what a felony is. We're talking about not a misdemeanor, we're talking about a felony. So if an individual has ever been convicted of a felony, they are not eligible to purchase or possess a firearm. A fugitive from justice, okay, again, we see this a lot in federal cases that someone's charged because they are in possession or try to purchase a firearm and they're a fugitive from justice. The third one is an unlawful user addicted to a controlled substance. So not as common, but we do see it, but under the federal law, that is a prohibition that someone is not permitted to purchase or possess a firearm if they're an unlawful user or addicted to a controlled substance. This one we see quite frequently if they're adjudicated mentally defective or involuntarily committed to treatment. And that is kind of going to go hand in hand with what we're going to discuss in a little bit regarding these risk protection orders. Someone who's an illegal alien is a prohibited person. Someone who has a dishonorable discharge from the United States Armed Forces. Someone who is renounced United States citizenship. And this one specifically addresses the restraining orders, but an active protection order, meaning a restraining order, right? We see those a lot, and we call them in Florida injunctions, right? So injunctions in the state level, also known as restraining orders. So that's a way someone can be prohibited from purchasing or possessing a firearm. And then talking about misdemeanors as opposed to felonies, if someone's convicted, right? Convicted is an important word, of a misdemeanor crime of domestic violence, or under indictment or information for a felony. So we see a lot on, this is a condition, when someone is arrested on a felony and they go to in federal court, and they have their initial appearance and they're released under supervision, right? So part of their supervision is going to be that they are not allowed to purchase or possess. They're going to have to get rid of any firearms that they currently have in their possession. So those are the 10 categories of individuals who are not eligible to purchase or possess a firearm, specifically dealing with federal law. So as I was saying, look at the laws. We need to pay attention to laws specific to the particular state someone's charged in or practicing in. So this is in addition to those 10 categories we just went through regarding federal law. Florida law prohibits persons who are adjudicated delinquent of a crime that would have been a felony if committed by an adult until the age of 24 or until a record is expunged. So I actually have a case right now where my client it was a juvenile case. He thought, I was actually out in New York, he thought he resolved it to a disposition which would not make him a convicted felon, but the disposition actually caused him to become a convicted felon. And now he was, and we see this a lot in cases, he was at a gun range firing his firearm, thought he had a lawful right to carry a firearm. He did not. And police are constantly watching people who go to gun ranges. Social media is a really big thing. So we're seeing a lot of cases in Florida, particularly where we are in South Florida, where people are charged either as a possession of a firearm by a convicted felon. And in this situation, it was possession of a firearm by a adjudicated delinquent. So that is specific to Florida. That is an additional prohibition to individuals who are allowed to purchase or possess a firearm. Another one, Florida specific. And law enforcement officers get this wrong all the time. So it's important, obviously, that's why the wording of the statute and to know what the laws are. So someone is prohibited in Florida, if they've received an adjudication withheld on any felony. So even if you receive adjudicated withheld, meaning you weren't adjudicated on the felony, or a misdemeanor crime of domestic violence, and 3 years has not lapsed since the completion of the sentence. So that 3 years is important, and people aren't always informed of or have that knowledge. They think, okay, well, I got a withhold on a felony, so I'm not a convicted felon, so I can carry a firearm. It's very important that on any felony or any misdemeanor crime of domestic violence, and 3 years must have gone by since the imposition of the sentence. And another prohibition in Florida, were recently arrested for a potentially disqualifying crime, which has not been dismissed or disposed of in court, right? So see it all the time. Just got a case this week. Client is arrested for domestic violence, aggravated battery on a pregnant female. That's a case I just got this week. And they have, you're supposed to be presumed innocent, and they haven't been convicted of anything, but they are not allowed to, their gun license has been, they're not allowed to carry. It's been suspended. They cannot carry, and it's a big problem because this particular client works as a security officer. So because he was merely arrested for that particular charge, he is not able to carry. Now, the goal is obviously to get the case dismissed before charges are filed, and hopefully expunge it off his record. And then if that happens, he can get his firearm rights back and be able to carry, and hopefully get his job back and be able to work security carrying a firearm. So very important to know the federal and Florida laws regarding that. So I'm not going to get too much into the next issues, but I thought it was very important to touch on, okay? I'm sure we've heard over and over again, stand your ground. I'm sure many of you who are watching this have had a case, have, moved forward on a motion for dismissal regarding stand your ground. So in Florida, and the statute that governs this is 776.012. In Florida, there is a stand your ground law, and that allows individuals to use deadly force if they reasonably believe it is necessary to prevent imminent death or great bodily harm. It's important to, again, I didn't put this in here, but the laws have changed regarding stand your ground and the burden of proof, right? If we as the defense file a motion to dismiss under stand your ground, and we make a prima facie case based on our motion, it is the state's burden to rebut our allegation. So and stand your ground, as far as obviously if you're successful on a stand your ground motion, that gets the case entirely dismissed. So there's a lot of nuances as to stand your ground, and that I wasn't going to go over that as part of this presentation. I just wanted to put it out there that self-defense, stand your ground is obviously important to recognize, important to think about when you have a case involving self-defense, and to get as much information from your client as to what happened, gather through the discovery process, and make a determination if a motion to dismiss based on stand your ground is an appropriate motion to be filed, pretrial motion to be filed in your case. And in Florida, pointing out, no, there's no duty to retreat. There's no duty to retreat before using deadly force if you are in a place where you have a right to be, right? We see these situations and where someone, and all over the news, someone tries to break into your house. There is no duty to retreat. And that's when we get into the Castle Doctrine, which provides legal protection for individuals who use deadly force to defend their home against an intruder. And that is under, you can look up the statutes, has all the information, Florida Statute 776.013. Use in public, there are restrictions on discharging a firearm in public or on a residential property. It's generally prohibited with the exceptions we just spoke about, self-defense or certain recreational activities. Another case I've had recently, a juvenile was charged with firing a firearm. He pulled over on the side of the road, kind of a deserted tree area, and was firing his firearm. He wasn't supposed to be doing that and was charged for doing that. So as far as there are also, it's important to note, there are places where firearms are strictly prohibited. Even if someone has a concealed weapons license, there are still places such as schools, government buildings, courthouses, polling places. If someone brings a firearm into the airport, that could result in you being charged with a federal offense. Establishments that, just trying to think, make sure I cover all of them off the top of my head. Establishments that serve alcohol, those are places where individuals can't bring firearms, even if they have a concealed weapons license, right? And we see, I think a really common one we see a lot is people bringing firearms into schools. Again, and what comes to the top of my head is back to school last month for Broward County, where where I live and do a lot of my practice, a mother actually had a firearm in her purse. She didn't realize she left it in her purse. And then when she went to her son's orientation, the firearm fell out of her purse and she was charged, because you cannot bring a firearm onto school property, again, even if you have a concealed weapons permit. So I would refer, as far as specific resources for both federal and Florida law, I would advise just to look it up if you have any questions. The key statutes regarding firearms in Florida for regulating firearms, including the purchase and possession and use. What we were discussing is Florida Statute 790. And then the other issues we were discussing, justifiable use of force, which includes stand your ground, and the Castle Doctrine. That's Florida Statute 776. There's a lot of really helpful information on the Department of Agriculture and Customer Services website, and that's the body that oversees the carrying of concealed licenses. And then obviously the FDLE, the Florida Department of Law Enforcement, they're the ones who do background checks for firearm purchases. So all those sites have really helpful further information. So now we get to, this was going to be, because I know you heard from Krista and Adam, this was going to be one of my main areas that I would like to speak about, risk protection orders. And again, not many people really know how to deal with them or have too much information, but we see them so much now. So what are we talking about? What exactly is a risk protection order? And I think I mentioned this earlier. A risk protection order is commonly referred to as red flag law. It's a civil court order that temporarily restricts a person's access to firearms and ammunitions. A risk protection order really takes away individuals a lot of their due process rights, and it gives a tremendous amount of power to law enforcement, right? It is a preventive measure designed to address situations where someone is showing signs of being a danger to themselves or others. So risk protection orders are governed by the Marjory Stoneman Douglas High School Public Safety Act under Florida Statute 790.401. And this act was enacted after the Parkland school shooting in 2018. So actually, I attended many years ago, but that was my high school, Marjory Stoneman Douglas High School. So I'm very familiar with the school and the case involving Mr. Cruz, Nicholas Cruz, bringing the firearm and the tragedy that happened as a result of that. But the risk protection orders were enacted because of that shooting, and have really been a tool that law enforcement uses a lot. And sometimes, obviously, it's needed and it's good and it's warranted. But other times, we've fought against them because it's not. So what risk protection orders can apply to any person who pose a significant risk, including people with mental health issues, those making credible threats, or those with a history of violence. So we've been seeing a lot, juveniles in particular, who are making death threats, which is obviously very serious, written threats to kill, second-degree felony, to different schools. And when not only is a criminal in that situation, not normally is someone charged criminally, but there's also this civil court order that is sought, meaning the risk protection order, in addition to the criminal case, because if there's a credible threat, they want to make sure they don't have access to firearms. Also, if someone is, Baker acted, displaying concerning mental health issues, that's another way law enforcement can seek to get a restraining order. Those with a history of violence, another way law enforcement can seek to get a risk protection order. So only law enforcement officers or agencies can file a petition for a risk protection order. So nobody else can. They're the only people that are allowed to be what's called the petitioner in these cases. So what does a petitioner mean? A petitioner means a law enforcement officer or a law enforcement agency that petitions a court for a risk protection order. Okay? And then the petition and accompanying affidavits must provide facts that give rise to a reasonable fear that the respondent, right, and who's the respondent? The individual who is identified in the petition who has to respond, but this person has to pose a significant danger of causing personal injury to themselves or others by having a firearm or ammunition in their custody, control, or possession. The burden of persuasion for, we're going to talk about a temporary ex parte risk protection order in a second, and a final and all those things, but the burden is reasonable cause. So once law enforcement or law enforcement agency files this petition for a risk protection order, the court must hold a hearing within 24 hours to determine whether to issue a temporary risk protection order. So a temporary risk protection order, it's a civil matter. It's very similar to an injunction case where someone files for a restraining order and a temporary restraining order is granted, and then a hearing is set. That's what very similar to that, okay? So if granted, right, so if reasonable cause is found by a judge, the temporary risk protection order lasts up to 14 days until a full hearing can be heard. During this period, the individual is prohibited from purchasing, possessing, or receiving firearms. So highly, these are time sensitive, and we're going to talk about, and there's going to be a video in a little bit played regarding a case that we had involving a risk protection order. So law enforcement petitions the court for the risk protection order. If granted, then what happens is the petition, law enforcement serves the petition on the respondent, okay? And once the respondent is properly served with the risk protection order, there's a search done to make sure that they have no firearms or ammunition in their possession, and then there's a hearing set within 14 days. So people think they can represent themselves. I do not advise that, as I don't advise someone to represent themselves in an injunction or restraining order. I don't advise someone to represent themselves in a risk protection order, because we're going to get into the consequences if one is issued against somebody. So if someone is served with the paperwork for a risk protection order, we highly recommend retaining counsel right away, because there's a lot that can be done to fight these risk protection orders. So someone's due process rights of being able to carry a firearm aren't taken away for up to a year, which we're going to get into. So a lot of times, if someone's served with a temporary risk protection order, and especially if they're going to retain counsel, there's 2 weeks isn't enough time, and we're going to get into how to prepare for a hearing like this, but many times 2 weeks isn't enough time to do the discovery process to prepare for a hearing such as this. So counsel can file a motion to continue the 14-day return hearing, and that's what this is saying, to complete a proper investigation and obtain discovery, including witness statements, police reports, and 911 calls. All the things you would normally do in the discovery process for a case, you should do when you're handling a risk protection order. And 14 days is not normally long enough to get that done. So you can file a motion with the court to continue the 14-day hearing, citing, I would like to conduct discovery, etc. So, there are ex parte orders. So if someone's deemed an immediate danger a temporary risk protection order can be issued without notice to the respondent, which could last until the full hearing, right? So what do you do leading up to the final risk protection hearing? So at that hearing, okay, normally what happens is the petitioner, meaning it's normally counsel from whatever law enforcement agency is seeking the risk protection order, and whatever agency that is, the proper jurisdiction is obviously depends on, you know, if it's, we're going to talk about a case in Pembroke Pines Police Department. So if it's Pembroke Pines Police Department, the petition needs to be filed in Broward County. If it's Aventura Police Department, it needs to be filed in Miami-Dade County, for example. And needs to make sure it's heard in the proper jurisdiction. But normally at that hearing, legal counsel for whatever agency is seeking the petition appears, and that's who's normally the petitioner, and they normally call whatever law enforcement agency or officer has knowledge about the individual who they believe poses a danger, and the information. They're called as a witness, and you get to question them, you get to cross-examine, and then you get to put on your defense. So at that hearing, the court reviews evidence and hears testimony from both sides. So again, the petitioner's side as to why they believe they need to seek protection, why they believe this person poses a risk, okay? And the standard in these that they have the burden, the petitioner has the burden, is the court must find by clear and convincing evidence that the individual poses a significant danger, okay? So we would, you know, we cross-examine the witnesses, we call our own witnesses, we do a lot, have a full hearing, like a mini trial to fight these risk protection orders. And a risk protection order that can be granted for up to a year, but if the court or the petitioner can also seek to renew or modify that order, and the risk protection order, they can, you know, attempt to, there's a lot that can be done throughout. We've moved to vacate risk protection orders that we're going to get into that have been put into place that should not have been put into place. So it's really something that us lawyers can work through the process and fight this so our clients' rights are not taken away. So that is the legal procedure regarding risk protection orders. Oops, and I just skipped. Okay, sometimes I get ahead of myself, but all right, so legal standards and evidence, again, the burden of proof, the petitioner, law enforcement, it's their burden because they're the ones bringing the petition to prove by clear and convincing evidence that the respondent poses a significant danger. And a lot of times I just discussed the law enforcement officer who has personal knowledge about this individual will be called to give testimony. I've seen them try to introduce mental health records, some individuals' criminal history, recent threats or acts of violence, such as what we were talking about earlier, that someone committed or is alleged to have put out a threat to schools and other individuals. So those are the type of evidence that are presented at the risk protection order hearing. The respondent has the right to a hearing to present evidence and to cross-examine witnesses, and I highly, highly recommend that to be done. And again, the respondent has the right to be represented by an attorney. Most people don't, if you're not represented, if you're unrepresented, if you go pro se, they don't know how to properly defend these. So I highly recommend, you know, handling a law firm such as ours that have experience in these type of cases. So strategies for defending against a risk protection order include challenging the evidence, questioning the petitioner's motives, presenting mitigating factors, And as we were talking about how the risk protection orders are very similar to a restraining or an injunction hearing, the same rules of evidence apply as in those hearings under section 741.30. So the same rules of evidence for these domestic violence injunction hearings or restraining orders apply for the risk protection order hearing. Consequences, right? There are serious consequences of a risk protection order being issued against someone. As we discussed, the respondent has to surrender all firearms, ammunition, and carrying concealed weapon permits to law enforcement. If a risk protection, even a temporary or final risk protection order is issued against someone, law enforcement will come to the person's house where they live, and they will search that house to make sure there are no firearm ammunition and you would have to surrender your carry concealed weapons permit. The respondent is entered into the Florida Crime Information Center, FCIC, and the National Crime Information Center, or the NCIC. So we've had situations, and it's where we've had the risk protection orders vacated, and even then, they still are showing up in the FCIC. So we've had to deal with that, how to make sure that gets cleared, because it's very significant. As if you violate an injunction or a restraining order, right? It starts out civil. These start out civil. But if you violate a risk protection order, it can result in criminal charges. And criminal charges, not misdemeanor charges, felony charges. It is a third-degree felony punishable by up to 5 years if found to violate a risk protection order. You know, I've had a case where someone had a risk protection order issued against them. They were in a car with somebody else and ammunition was found in the car, and they're in violation of their risk protection order. So these need to be litigated and fought, because the consequences of one being issued against someone for up to a year and then potentially violating the risk protection order that's put into place are very, very significant. So the petitioner, meaning law enforcement, we spoke about this a little bit, but they can seek an extension of the injunction. But once again, they can't just say we're seeking to extend this risk protection order, right? They can't just say that. They must once again meet the burden of proof at the hearing. And then again, it's like the same process as the initial. The respondent maintains his rights to oppose the petition for an extension. It's the court's authority to extend the risk protection order. It's much more limited than the court's authority to extend injunctions in domestic violence cases. So meaning the court can extend easier, and it happens more often, a injunction restraining order case than a risk protection. And the deadline, the petitioner, the state's request to extend the injunction must be made within 30 days before the natural termination of the injunction. Okay. So here's an example, I put this in here, of an order. So this was a case where where we petitioned the court to terminate the risk protection order before the expiration, because generally if a risk protection order is issued, it's normally issued for a year. So this was an example of an order that we put together that we won, and because we proved that it was no longer justified for this individual to need to have a risk protection order. Okay, so and that we did that by presenting evidence to show by a preponderance of the evidence that the respondent does not pose a danger by having access to the firearm. So this was granted, but it's very important after you have a hearing and hopefully you're successful in vacating the risk protection order, it's really important to make sure certain things are put in the order, okay? So that the parties, this one deals with an agreement that the individual no longer poses a danger of causing personal injury to themselves or others by having access to firearms or ammunition in their custody or control, or by purchasing, possessing, or receiving firearm ammunition. So, this language is really important in an order. Petitioner shall, as requested by respondent, return any firearms, ammunition, or license to carry a concealed weapon or firearm that was surrendered by the respondent only after complying with all applicable provisions of federal and state law. So, assuming they otherwise qualify, when they did that sweep of the person's house and their firearms and ammunition was taken away and they surrendered their concealed weapons license, they are entitled to get that back once the risk protection order is vacated. The clerk of court shall immediately forward a copy of this order to the Department of Agriculture and Consumer Services and the petitioner. So that's once this order is signed by the judge, the clerk of the court is instructed to send the order. And then once the Department of Agriculture and Consumer Services, if they're going to receive the order, if the respondent's license is suspended to carry a concealed weapon or firearm, they have to then reinstate their license to carry. Okay. And also, this is another important thing to make sure that's in there, that the petitioner, meaning law enforcement, shall promptly remove the risk protection order, in this case, from any computer-based system in which it was entered. Remember, we spoke about it being in the Florida Crime Information Center and the National Crime Information Center, to make sure that is taken off, removed from there. And again, we've had to, even despite having an order like this, client goes and they find out that it's still in the system. We've had to jump through hoops to make sure that it's out of the system. So once the order is vacated, I would make sure you follow up to make sure that it has been removed and that these things have been done. Okay, so what I am going to momentarily be showing you is a situation. I just want to, and I know you heard from Adam earlier, but it's kind of good to put this into real life perspective. And Adam's going to speak in this video that we made because people don't realize this really happens, and seeing it happen, I was actually a part of, this was my case. And it was a case involving my client and her young juvenile daughter. Okay. And a risk protection order was sought against them. Luckily, they had already hired us on the related criminal matter. So as I said earlier, a lot of times when there is a criminal matter, there's also a related risk protection order civilly that is sought. So what happened in this case is they already had us as counsel, and Pembroke Pines, you're going to see police department, shows up at their residence to serve the risk protection order on both. They were seeking a risk protection order against mom and juvenile daughter. So they get to the residence, they knock on the door, scary, bunch of law enforcement officers with Pembroke Pines Police Department. And my client, she was smart. She called me. She's represented. She called me, myself, and you'll see my partner David was also on the phone. She called us and she said, "What do I do?" So normally in these situations, I say to law enforcement, we represent this individual. We would like to have them, if you're going to try to serve them, we'd like to have them served at my office. I have them come to my office and they serve accepting service, right? So you'll see in the video, I tried to say, can you send me a copy of the petition? Can you send me a copy of the paperwork? Can you serve them at my office? They said, no, she needs to be served now. This is a court order by a judge. and she's just gonna be signing for her court date, okay? And so I made it very clear that she is not agreeing to anything in that petition. She is only accepting service for that court date. And you'll hear me say that, and then one thing led to another. Body worn camera went off at some point, and my client, doesn't understand. That's what she has us for, exactly what she was doing. She sends me the paperwork the next day, and it's not her signing so we can have a hearing to fight the risk protection order. It was signing an agreement. They tricked her and coerced her to sign an agreement agreeing to the risk protection order for a year. So when that happened, you can imagine how I was, so upset when I found this out. So when I found this out, I immediately ordered the body worn camera, reached out to the petitioner's attorney, reached out to file all kinds of motions and to fight this, to get a hearing. And then we were able, it took some time when it should have never been issued to begin with, we were able to get the risk protection order vacated. But this is just an example of how things happen for a risk protection order. So I'm gonna play the video now, and then I will answer questions when it's concluded.
Hi, I'm Adam Rossen from the Rossen Law Firm, and on today's video, we're going to show you body-worn camera videos from Pembroke Pines Police Department trying to serve a risk protection order. So let's talk about a risk protection order. What a risk protection order is basically it's a restraining order to take your guns away. This was passed in 2018 after the Marjory Stoneman Douglas high school shooting, and there's many problems with this law. First of all, it was passed very hastily, and it really takes away a lot of due process from our clients and gives a lot of power to the police. And in this particular case, Pembroke Pines police officers went to our client's house to serve a risk protection order against our client, the mother, and our client, the high school minor child. There was an incident and with having access to guns, and they came to serve both of them with this civil restraining order.
Yeah, you're going to have, this is a civil. This has nothing to do with the criminal case. Let me just explain that to you. Okay. This is specifically the city against the fact that you currently own firearms and have access to firearms and are not responsibly keeping them locked in a safe and preventing your daughter from having access to the firearms. So this is a civil order. It's a restraining order basically against firearms, ammunition, and your concealed weapons permit. This has nothing to do with the criminal case. This is something in addition. So you don't have to answer any questions. You don't have to tell us anything about the civil case. This is specifically a risk protection order. That's a restraining order against firearms, ammunition, and your concealed weapons permit. So that's why you would have to sign accepting the fact that you have a final hearing where you can have somebody like a legal attorney or a lawyer represent you at the final hearing that's going to be in about 14 days. So you're just accepting that you're getting your court date. That's what you're signing, essentially, saying that you're accepting your court date.
The problem or the issue is that we were already retained, meaning we had already represented the mother and the child. And Susan Lawson from my office, who is a board certified criminal trial law expert, was the one working on the case. And when you watch the video, you hear her on the phone speaking to the police officers.
Ms. Ford, you can accept servicing, saying you received it, but you're not agreeing to anything in there.
Okay.
You're not agreeing to stipulations, but she'll.
Okay, so by signing that you have a final hearing, you obviously wouldn't be agreeing to it. You're agreeing that you're going to go to the hearing. It's basically what you're signing, saying that you received your court date and you're going to go to the hearing. If you don't go to the hearing, just so you know, the judge is going to grant the order for the 12-month time.
And the total encounter is about 45 minutes long. We're not going to show you the entire counter on there, but we're going to have different clips from this video. And what you're going to see is the police officer over and over again telling our client, well, your lawyers don't have your best interest in mind.
Just so you know, you can't decline receiving. You're being served essentially with a civil order from a judge.
I'm going to receive it, but
you have to sign saying that you received it, because
wait. Sorry.
Okay, but if you don't sign, you're going against the judge's orders. The judge is requiring you to sign saying you received your court date. You have to sign accepting your court date.
Okay.
I'm just letting you know this attorney is going to mess you up.
Okay.
They're not doing what's in your best interest. At least, I hate lying, I'm sorry. At least sign accepting your court date.
Just sign the paperwork, ma'am, sign the paperwork. And they keep telling her that it's not an admission of guilt and it's not, all she has to, that it's not going to be counted against her. All she has to do is sign the paperwork to get her court date, right? Seems innocent enough, doesn't it? And when you watch the video without having full context, it seems like, well, why would Susan and our attorneys be so adamant and distrusting of the police, right? They continually say, just sign the papers. It's really easy. It's not, you can still fight it later, right?
I would like to see it before I have her sign it.
It's an injunction. This is a court order from a judge. She has to sign this. She has to sign saying she has a final hearing in 14 days. And I'm going to give you that date. But essentially, that's when you can prepare everything for her and represent her and say all the reasons why she doesn't meet the needs for a final order of 12 months.
And Susan's adamant about wanting to see it. Well, why don't the police officers show it, right? They refuse. She's adamant about being on FaceTime and being able to read it and being able to be part of every single piece of the process to view exactly what our client's going to sign.
Can the attorneys accept service on her behalf?
No, we cannot, because the whole thing behind the risk protection order is that she is served with it and that she is in compliance with the order.
Now, to me, that seems reasonable enough. But the police, they don't want it. They don't want her to do that. They want to do their things. Well, why, right? Why? Well, take a look at the video and look at what our clients actually signed at the end of the video when the police officer basically cuts out the body-worn camera and says to our client, look, your attorneys are hurting you. They're making this worse. Let's just kind of talk person to person, and click, and the body camera goes off. And our client, hangs up the phone with our attorney. So it makes you wonder.
Just so you know, they're making it worse. I'm going to go on.
We're going to show you exactly what our client signed. And what our client signed was an agreement, a joint stipulation and agreement to accept not just the court date, but the full restraining order against her. So she was tricked by the police over and over and over again. So our firm's distrustment of the Pembroke Pines Police Department was validated and was there because they lied to our client. They tricked our client into signing these papers to avoid or prevent the hearing, so we couldn't even fight it, right? So when you look at everything in a whole, this was shadiness. This was lies from the police department. And it should be noted, one of the papers that they had our client sign was something saying that she had the opportunity to review the paperwork with the lawyer of her choosing. Well, I think the body-worn camera evidence shows that it's not that was not true. That's a bald-faced lie. Bald-faced lie by police that are supposed to serve and protect and be honest to people. So our board certified attorneys' concerns were completely validated.
Okay, so that was that. I hope you can see. I think the video speaks for itself, but that is why it's so important for individuals to have attorneys. And she even had an attorney, and look what happened. But then thankfully we were able to take care of it. But how awful was that? She was specifically told, they said I was trying to trick her, but that she was just signing for the court date so we could have the hearing in 14 days, or I'd probably likely move to continue the 14-day hearing so I could have time to prepare. But what happened in that situation? Somehow a joint stipulation was signed, and we dealt with it. But that's very, very significant what happened, because we went over a little while ago, as you heard, there are serious consequences that come into effect when a risk protection order is issued against somebody. So I am going to go through some questions now as far as, let's see. So the first question someone wanted to know is, what are the current legal implications for individuals with a domestic violence restraining order under the law? So as far as a domestic violence restraining order, how we spoke about that, when a domestic violence restraining order is issued, even if a temporary is issued, one of the conditions are that you cannot possess firearms or ammunitions. So again, that's why these cases, although they're civil in nature, the due process and potential consequences that both of these things have are really significant. Okay, so we've had individuals who a temporary restraining order, a temporary injunction has been issued against them, and it's affected their employment because they need a firearm to carry their rights. So significant consequences. Next question. How should attorneys advise clients who are subject to a risk protection order, particularly in relation to their firearm rights? So we would advise someone, if a risk protection order is sought, or a temporary is issued, or even a final, they need to get rid of, they need to surrender all their firearms and ammunition. Next question, how do you challenge a risk protection order, and what evidence is needed to contest one? So we kind of went through that earlier. It's like a mini trial that we would do, and really it's a discovery process. Again, gathering records, speaking to witnesses, gathering documents, all those things to challenge the petitioner, saying that this person poses is a significant danger. So these are all things that we want to have. We want to know, we want mitigation, we want to know that person's life story, and to show that there's not a need for a risk protection order in this situation. So there's lots of ways. Preparation for a risk protection hearing is a lot of work, but there's a lot that can be done to be successful in fighting these. And I highly recommend that never just stipulate and agree, okay, fine, I'll get rid of my firearms and ammunition for a year. Never agree to that because of the significant consequences. Really, really challenge these, because you know what? Why would you stipulate to a year on a risk protection order when you're going to get the same result? Worst case scenario, if you lose, when you can really fight these with doing the proper discovery and gathering the evidence and presenting it to the court. So the next question is, what should attorneys be aware of in terms of adapting their legal strategies and advice in light of these recent amendments? So again, it's very, very important. That's why it's great we get to do these CLEs, as far as to be up to date on the law and to be able to fully advise your clients. So let's see. So the next question is, are there any anticipated legislative changes or proposals that might further impact firearm laws in Florida? How should attorneys prepare for these potential changes? Stay up to date on your CLEs, stay up to date on your research. And I fully anticipate, based on the everything that's going on in the world today, and that these firearm laws, they're ever changing. So it's very, very important to stay up to date. So as far as what we went over, the firearm laws that are in effect today, the risk protection orders. There is the slide that's up right now. If you scan it, and we'll be happy to provide the materials, but that has a lot of helpful information. It's a resource to risk protection orders. So lots of different resources out there. It was a pleasure speaking to all of you today. My information is going to pop up. I'd be happy to share. That's a code for me. Again, my name is Susan Lawson. I'd be happy to share. If anyone has any questions, you could reach out to me. Also, my email is susan@rossenlawfirm.com. Reach out to me anytime. If anyone has any cases they'd like to discuss, any questions they have regarding Florida firearm law, specifically, I've done, as you can see, a lot of risk protection orders. So any questions or issues, or want to pick my brain, I'd be happy to discuss this further with you. And it was a pleasure speaking to you all this afternoon. I thank you for your time and attention, and I hope you all have a great rest of your day. Thank you.